We're gonna be doing the 100 words per minute and 120 words per minute classes, starting with the drill. Class number 26, 100 words per minute. I haven't been practicing as much as I should be, so I'm actually kind of rusty now. Sometimes we just need to take a rest from something that we're practicing. It helps develop skills too, I think. Okay. Sorry, I'm just moving something. There. I had my earbuds that were playing music next to my microphone, so I just moved it. Okay, now we should be doing the 100 words per minute drill. Okay, I'll start it up now.
Welcome to drill practice. We'll start out.
I think she's a little low. Maybe just the volume. She's competing with the music.
With some, I guess, words of wisdom. I have this book called 14,000 Things to Be Happy About. And so we're going to read some of the things to be happy about from this book as just a drill. Get our fingers warmed up. Okay, here we go.
Doesn't seem like she's loud enough. Maybe I'll put it at 8.
Picnic color coolers. A rich, spiced chocolate drink. The Eastern Seaboard. Old-time radio shows. Red carpet treatment. Toddlers' vocabulary. French toast, butter, and powdered sugar. Early apples. Fresh strawberries.
Hello, Joel.
Roast pork. Uneven parallel bars. Cherry tomatoes stuffed with deviled ham. Driving under an overpass during a storm.
Oh, this is called
Fresh
stenography.
Ginger muffins. Coffee steeped with cinnamon sticks and cloves and then iced. Bags of magic tricks. 8 hours of sleep. Lying on your back in a snowy field and making an angel by moving your arms in arcs. Writing a screenplay. The Florida keys, briefcases, a 10-gallon jug of fruit salad.
What? Salad.
All right, we'll stop. We'll stop with that one.
I did pretty okay with that. Parallel I spelled wrong.
And move on now to the 100 most used phrases.
Okay.
And these are phrases that are just spoken in general, not necessarily phrases that you may have learned to brief in school, but maybe you did. So either way, I'll read them and you can use your brief or you can write them out. But again, this is a list of the 100 most used phrases. I will not read all of them right now, but we'll read through some of them. Okay, here we go.
Okay.
Yes, sir.
Yes, sir.
Of the. In the. No, sir. Did you. On the. To the. I did. That is. I was. It was. You were. When you. He was. At that time. And the. I am. You say. Were you. How long. That was. Was it. There was. What did. That you. At all. I don't know. I do.
Yeah.
At the. To you.
Oh my god. Sometimes I forget how I write I don't know. I don't know why. Because there's no B in it. That's why. I had to compromise and not put a B in it.
That you. At all. I don't know. I do. At the. To you. With the. At the time. It is. You did. Is that right? Didn't you? How many? What was? How far? In this. Did you see? Do you know? That the.
Okay.
All right, well, we'll stop there. And now let's practice some letters and numbers.
Now letters and numbers.
Letters and numbers. Here we go.
Is it just license plates then?
J.
No. Skipping this.
Q.
I'm not doing just letters and numbers.
Okay, moving along. Let's practice some dates.
Nah, let's not practice some dates. How about that?
February 5. March 5.
Oh, she goes on for the rest of the video?
February.
Just doing dates?
And that will conclude our...
Okay, the drill went by pretty fast because I refused to do the numbers and letters and just dates. Oh, shoot. I moved on to the wrong class. My bad. Class 26.
Welcome to Jury Charge in Literary Practice. Let's get started with this jury charge.
Jury charge. Okay.
Here we go. Reasonable doubt is defined as follows. It is not a mere possible doubt because everything relating to human affairs and depending on moral evidence is open to some possible or imaginary doubt. It is that state of the case which, after the entire comparison and consideration of all the evidence, leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charge. Evidence is either direct or circumstantial. Direct evidence is evidence that directly proves a fact without the necessity of an inference. Circumstantial evidence is evidence that proves a fact from which an inference of the existence of another fact may be drawn. It is not necessary that facts be proved by direct evidence. They may be proved also by circumstantial evidence or by a combination of direct and circumstantial evidence. Both direct evidence and circumstantial evidence are acceptable as a means of proof. Neither is entitled to any greater weight than the other.
I didn't do very well on that. Circumstantial evidence. So. Okay. I would have made it go a lot faster if I knew the brief.
Let's see, we had imaginary doubt.
Imaginary.
A moral certainty.
A moral certainty.
Circumstantial evidence.
Circumstantial evidence. What else?
So we had direct evidence and circumstantial evidence.
Oh, direct evidence also has a brief. Okay, cool. They follow the same pattern too.
All right, let's try a little bit of literary practice now.
I don't think I'm gonna remember that. Literary practice. What's she gonna read? I hope it's something interesting.
Ready?
I feel like everything is too loud. It's drowning me out. Okay.
Helen Ross was a good friend who taught teachers, doctors, and psychiatrists and consulted with professionals working with children.
How do I write psychiatrist? Chris.
And family, doctors, and psychiatrists, and consulted with professionals working with children and families all over the world. She was one of the great people of our age in the understanding of the dynamic development of human beings. After one operation for cancer and some subsequent therapy, Helen chose to refuse treatment when her cancer reappeared. One day, when I visited her, I found Helen very frail, yet interested in all that I had to tell her about our television work and her Pittsburgh friends. Some of the time, I just held her hand and we said nothing. We didn't have to. After one of those silences, Helen said to me, "Do you ever pray for people, Fred?" "Of course I do." So I said, "Dear God, encircle us with thy love wherever we may be." And Helen replied, "That's what it is. Isn't it? It's love. That's what it's all about." Helen was 88 when she died. She had spent most of her adult life working at understanding the complexities of human growth and development, and her summation of life was that love is what it's all about.
Pittsburgh. I'm having trouble writing stuff right now. All about. That one has a brief. Interesting. Summation.
Excuse me. Okay, so now let's work on a different jury charge. A little more jury charge practice. Here we go.
Here we go.
The police worked to help the state in providing evidence. The police helped by identifying witnesses and providing the state with the people's exhibits. After the witnesses had all been called and the attorneys have given their closing statements, then the judge had an opportunity to instruct the jury on the points of law in the case so that they could apply the law to the facts that they had to review in determining the guilt or innocence of the defendant. Their decision resulted in the defendant being sent to the state penitentiary without any hope for parole. When the judge makes his charge to the jury, the judge reminds the jurors that they are to act as any prudent person would act in determining the verdict for the case. As prudent people, if they found that there was not enough evidence to prove that the defendant had committed the crime, they would have to move to release the defendant. The defendant must be determined to have committed the crime beyond all reasonable doubt. In this case, the defendant was determined to have committed the crime of murder. As a result, he was subjected to confinement until the governor granted a reprieve. The governor granted a reprieve because new evidence had been located. The jurors acted as prudent people and returned a verdict of guilty because they examined the exhibits and the testimony of the witnesses and determined that there was enough evidence beyond a reasonable doubt to convict. In this jury charge to the jury, the judge reminded the jurors of how they were to act. He reminded them of their duty to examine the possible verdicts. The jurors were told that they should base their decisions upon the facts in the case and not on their emotions.
Emotion. Okay. Not an E, an EU. Very inconsistent with that.
All right, I found an article in the NCRA Journal of Court Reporting, and it's on kind of like tech tips.
Tech tips?
And so I'm just going to read a small little portion of it.
You got 7 minutes left in this practice.
This particular section of this article is regarding the passwords that you use.
Passwords, cool.
Here we go. Christine Phipps, RPR, NCRA Technology Committee co-chair, reminded reporters to be smart about their passwords. Recently, Splash Data released its annual list of the top bad passwords. If any resemble your current passwords, Phipps advises, you may want to consider changing them immediately. A post on iPhone JD covers 10 more passwords that you should never ever use. Author Jeff Richardson urges readers to use complex and unique passwords on each of the websites that you visit. I know that was very short.
It was very short.
Hopefully that's helpful, good information. So it says, let's see, one of the websites they referred to was iPhoneJD.com.
You can just write passwords like that.
And the other one was called Splash Data. Oh, then it says you can read there. It does give a website. It's called teamsid.com/worst passwords 2015. So.
Well, that article's from
You want to do
2015.
some further research on that and make sure you're not using any of those passwords.
What an incredibly uninformative article.
Alrighty, so let's get back to one of our jury charges here and do a little more jury charge practice.
Jury charge practice again. I do like jury charge practice. Jury charge.
Ready? However, in any case, based on circumstantial evidence, if the circumstantial evidence is susceptible of two reasonable interpretations, one of which points to the defendant's guilt and the other interpretation to his or her innocence, you must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to the defendant's guilt. If one interpretation appears reasonable and the other interpretation appears unreasonable, you must accept the reasonable interpretation and reject the unreasonable. Murder is the unlawful killing of a human being with malice aforethought. Malice means either an expressed intent to kill or an intent to commit an act dangerous to human life with knowledge of the danger to and with conscious disregard for human life. Aforethought means the malice must precede the act. First-degree murder occurs when the killing is committed with malice aforethought and a deliberate and premeditated intent to kill. Deliberate means determined after careful thought and weighing of the consequences. Premeditated means considered beforehand. The law does not try to measure in units of time the length of time during which the thought must be pondered before it can ripen into an intent to kill that is truly deliberate and premeditated. The time will vary with different individuals and different circumstances. The true test is not the duration of time, but the extent of the reflection. A cold, calculated decision may be arrived at in a short time, but a mere unconsidered, rash impulse will not amount to deliberation and premeditation, even though it includes an intent to kill.
That just went over my head. I was just trying to copy down what I was hearing. Forethought. Okay. Forethought, okay.
Some of the words in there. Let's see, we had circumstantial evidence.
Once again, I forgot the brief for it.
Interpretation. Interpretations.
It looks like my machine just disconnected. I have to reconnect it now.
Malice aforethought. Malice aforethought. Deliberate.
Turn it on, off.
Calculated.
Calculated.
Calculated decision.
Let me turn it off now.
Alrighty. Well, we'll...
Ah, okay. It's working now. Sometimes it just disconnects. There's no rhyme and reason for it. Okay, we're continuing to the Q&A.
Welcome to Q&A practice.
Q&A practice.
Let's get started with just some two voice. We'll just have the questioning attorney, the defense attorney, questioning a witness. Get our fingers warmed up.
Two voice sounds delightful.
Here we go.
Let's see if I get it correct.
Do you remember the conversation you had with Mrs. Bold regarding that? Well, she asked me whether she could hang her clothes, and I said yes. And was that the day she did hang them? Yes. About when was it? Well, the time I do not know. I really don't remember. Where did this conversation take place? It was in my backyard. Was anyone else present at the time? My daughter was there. How old is your daughter? 4. And what did you tell Mrs. Bold about it? I didn't tell her anything about it. Well, did you tell her that she could or could not? I said that she could hang her clothes. And she proceeded to take advantage then of your facilities? Yes. Did you help her the first time that she was there? Yes. She was in a hurry, and I helped her hang them up. At about what time of day was that? Do you remember? Well, it was in the morning. I don't know the exact time. Well, would you say it was 2 hours before noon or an hour before noon? Oh, well, around 9, I guess. And was the dog there at that time? Yes, it was. Incidentally, what kind of dog is this? It's just a dog. How large is the dog? Not very big. Would you say he is 2 feet high if he is standing on 4 legs? Gosh, I don't know. Do you know how heavy the dog is? No, I don't. I have never weighed it. Approximately how old is the dog? Around 9. I don't know exactly.
Okay, that wasn't too bad. I got most of it right, besides incidentally, which I did not know how to write. Mentally.
All right, so now let's do a little practice with the transcript. And we will have, looks like, well, maybe not. Maybe we'll just have the one attorney for a little bit. Looks like the defense probably doesn't pop in for a little while, but we'll see.
Okay.
So we'll start with the plaintiff. Okay, where was he staying at that time that the accident occurred? I believe in Atlanta. Did you ever live with Mr. Majors? No. Had you ever known Mr. Majors to be arrested for any kind of felony? Yes. Okay, and what kind of felony would that have been? Possession, I believe. Possession of cocaine, marijuana. Okay, that may or may not be a felony depending on the quantity. I don't know. And it's not really for us to go into. I was just trying to find out the status as far as convictions go. So that's the only kind of criminal background that you knew Mr. Majors to have. And was that prior? This arrest, we'll call it, for marijuana, was that prior to the time of this accident in 09? Before? Before? Yes. Had you ever known Mr. Majors to use cocaine? No. Even to this day? No. Before the date of this accident back in August, and I'll say August 7th of 2009, had Mr. Majors ever driven that 2006 Toyota Camry? Yes. Approximately how many times before this accident had he driven that vehicle? Approximately 6 to 7 times. Now, prior to the date of the accident, on the 6 or 7 times that he had driven that vehicle, had it been with your permission that he drove that vehicle? No. Had it been with Mr. Bradford's permission that he drove that vehicle? Yes. Did Mr. Bradford have a set of keys to the vehicle? Yes. Did you have a set of keys to the vehicle? Yes. Okay. On the day of this accident, who was, strike that, was there more than 2 sets of keys to the vehicle? No. Okay. On the day of the accident, whose keys, if keys were used, was Mr. Majors using to drive that vehicle? If you know, Arthur's. Did you have knowledge on the day of this accident, prior to the time before the accident occurred? Did you know that Mr. Majors was going to use that vehicle on that day? No. Is the first time that you found out that Mr. Majors had used the vehicle on that day of this accident after the accident had already occurred? I don't understand. Okay, that was a bad question. You indicated that before the accident occurred, you didn't know that Mr. Majors was driving the vehicle on that date. Is that correct? True, yes. At some point on the day of the accident, did you find out that Mr. Majors had driven the vehicle after the accident, but on the day of the accident, right? See what I'm asking? When did you first find out that Mr. Majors had driven the car on the day of the accident? When did I first find out? The day of the accident. Good, thank you. And that was sometime after the accident had already occurred, right? It was later in the day after the accident. Yes, right? Yes. Okay. Now, did you ever object to Mr. Majors or tell him not to drive this car that was in your name at any time before the accident occurred? Yes. When did this happen that you objected to his driving the car? About a week before the accident. And what did you say, if anything? I told him and I told Arthur that I didn't want to be responsible if anything was to happen to the car since my name was on it. What caused you to say that? Because when the time of the accident, when Keith had possession of the car, Arthur was in the hospital. And that's what I said. What I said, you know, while he was in the hospital. Then I felt I should have the car at least, you know. When did Arthur go into the hospital? Around that time. I'm not for sure, but it was around that time. He was in the hospital maybe a week before the accident. And he was in the hospital at the time on the day of the accident too? Yes. What was he in the hospital for? He had somebody ran him over in a car, a hit and run. So you indicated that approximately 1 week before this accident occurred, that we're here talking about today, that you had told Mr. Majors and Mr. Bradford that you didn't want Mr. Majors driving the car because you didn't want to be responsible? Yes.
Having trouble using my new briefs. But I did pretty okay that time. It went on for a while, so let's do the test. Let's see how I do on the test. Oh, she's loud.
This will be a 100 practice Q&A test. 100 practice Q&A test. Our plaintiff attorney is Mr. Schaefer, SCHAEFFER. Defense attorney, Mr. Raya, capital RIELA.
Okay.
We'll start with the defense. Mr. Lowell, prior to the incident that we're discussing, the injury to the foot, knee, hip, back, and ankle, have you ever had symptoms of anxiety or depression in the past? No. Okay, I want to ask you a couple of questions more specifically about your injury. Are you in pain as we sit here today? Yes. Okay, and what type of pain is that? Is that a stabbing pain or a throbbing pain? A dull ache? Can you describe your pain? Can we first describe what body part? Let's start with the right ankle. Right ankle. Numbness, horrible chronic pain. Tingling. Actually feels like I'm bleeding out. Unbearable. When you say unbearable, if you had to rate that pain on a scale of 1 to 10, with 10 being so bad, you'd have to, get an ambulance and go to the doctor because it's horrible, and 1 or 2 being kind of a chronic nagging pain that if you were thinking about something else, you might even forget about. Where would you rate your ankle pain as we sit here today? An 8, 9. Okay, And what about your foot, your right foot? The same. Would it be the same? And what about your right knee? Right knee is about an 8, 7 to 8. So the knee is just a little bit less than the ankle and foot. Correct. And what about your right hip? I mean 10, 8 to 9, 10. My worst bearable pain. Right now, at this time, it's probably an 8. Okay, and your lower back? Lower back is about a 10. So you want to go to the hospital or doctor right now because of the pain in your back? As soon as my medication wears off, yes. Okay, as we sit here right now, though, with the medication that you've taken a 9, so you're finding it very uncomfortable to sit here today, correct? Please feel free, by the way, to walk around or stand up, or if you need to lie down on the floor. Whatever makes you comfortable. Thank you. Okay, I want to ask you, were there activities that you did apart before this injury that you can't do anymore? Yes. Can you tell me what some of those activities are that I am not able to do outside? Let's start with outside of your job, because we know that you're not in your job right now. I'll ask you a couple, and maybe they'll spark some ideas for you. Can you drive a car? Yes. So pressing on the gas pedal or the brake, is that okay for you? No. For you to drive your car? No. Did you drive your car here today? No. How did you get here today? My fiance. Okay. Do you drive your car at all, or any car at all? Periodically. When you say periodically, how often would you estimate? Probably once a week, a couple times a month.
I didn't do very good on that. I tried my best though, Mr. Bowl.
All right.
That's the end of that. We're moving on to 120 now. First, let me click into 27. Okay. Let's do the drill for 120 words per minute now. Ad break should be starting in like 10 minutes, so we'll be able to get through this, I think, before the ad break begins.
Welcome to drill practice. Let's get started with some tingle tamers. And these are just pairs of words.
Maybe I should have a limiter on the game audio. Sorry, the audio for the YouTube video. I'm gonna do that in the future. I'm gonna have a little limiter on it so that it's not too loud, but it makes it
that are designed to just get your fingers moving and get them warmed up.
I think this is good.
Ready?
Ready.
Here we go. Unique collection.
Oh, whoops. I accidentally... Let me try that again. I forgot to click into Notepad++, so it ran a bunch of keys on the video.
Let's get started.
I had this at -5 before.
With pairs of words that are designed.
Okay.
Here we go. Unique collection. Strong foundation. Overwhelming praise. Luscious blooms. Vegetarian conversion. Walled schoolyard. Sensation captured. Honeycomb design. Manual overdrive. Sparkling perfection. Disorganized gaggle. Extensive damage. Sun worshippers. Influences.
Ow. Is this too low? He's fine. I'll put it back at 0.
Blended. Panoramic vista. Automatic dishwasher. Superior workmanship. Acclaimed performance. Mechanical engineering. Bottle capacity. Organizing priorities. Newest patterns. Legendary standards. Fabric embroidered. Island prospered. Current exchange. Recreation available. Colonial dwelling. Unique collection.
Unique collection again.
Kitchen appliances. Noticed instantly. Dazzling sunlight. Imposing mansion. Non-flammable surfaces. Shimmering brightness. Forbidden discussion. Macadamia nuts. Tourists jammed. Various desserts. Attractive casinos. Reputation deserved. All right, now for some names and spellings.
Names and spellings. I'm gonna get those wrong. It's gonna be
Ready?
embarrassing.
Robert Johnson. Johnsson. Misty Felice Nelson. Nelson. Kimberly Ann Furr. Furr. Hazel Murillo. Murillo. Tara Williams, Williams. Madison Kurz, Kurz. Kathy Sellers, Sellers. Erica Iglesias, Ygliesias. Ruth Collins, Collins. Diane Tropia, Tropia. Brenda Hope Cannon, Cannon. Samantha Amato, Amato. Janet Mahoney, Mahoney. Joyce Husby, Huseby. Valicia Marseille, Marseille. Deborah Cooley, Cooley. Seema M. Hecht, Hecht. Regina Ann Dewhurst, Dewhurst. Ellen Oakes, Oakes. Dawn M. Spano, Spano. Lisa Ann Wilson, Wilson. Danielle Coughlin, Coughlin. Megan Orris, Orris. Lisa K. Henderson, Henderson. Magdalena Serzba, Szzerba. Carol Ann Rouse, Rouce. Helen Laverty, Laverty. Now let's try some cities and states.
Cities and states.
Ready? Mesa, Arizona. Nipomo, California. San Francisco, California. Yucaipa, California. Aurora, Colorado. Crested Butte, Colorado. Jacksonville, Florida. Palm Beach Gardens, Florida. Winter Park, Florida. Arlington, Massachusetts. Charlotte, North Carolina. Lincoln, Nebraska. Lakewood, New Jersey. Hornell, New York. Plain City, Ohio. Phoenixville, Pennsylvania. Murfreesboro, Tennessee.
Oh, ad break's gonna start soon.
Menominee Falls, Wisconsin. Charleston, West Virginia. Danielle, Wyoming. Might be Daniel, Wyoming.
Wyoming.
All right, that will conclude our drill practice.
Great timing. Drill practice has concluded. Ad break starts in a few seconds. Woohoo! Ad break is starting soon. I just ate a cookie. Rejuvenated now. Let's try the jury charge and literary practice.
Welcome to literary and jury charge practice. Let's get started with some jury charge practice. And the title of this jury charge, or the subject, is weighing evidence.
Weighing evidence.
Ready? Right, here we go. Members of the jury, you are the sole judges of the truthfulness of the witnesses and of the weight that is to be given to their testimony. It is not your duty to accept the testimony of witnesses blindly and follow it passively, but it is your duty to consider it with care, subject it to your experience and judgment, and accept it only so far as it appeals to you as being reasonable and true.
Okay, I'm going to redo this. Let's restart.
Right,
Starting with members of the jury.
Members of the jury, you are the sole judges of the truthfulness of the witnesses and of the weight that is to be given to their testimony. It is not your duty to accept the testimony of witnesses blindly and follow it passively, but it is your duty to consider it with care, subject it to your experience and judgment, and accept it only so far as it appeals to you as being reasonable and true. While it is your duty to accept as true the uncontradicted testimony of an unimpeached witness given with apparent fairness and candor, still you are not obliged to accept the testimony of a witness as true merely because there is no testimony contradicting it. If it contains contradictions or improbabilities which, standing alone or in connection with other evidence in the case, furnish reasonable grounds for believing that it is not true, you are at liberty to so regard it. If you find and believe from the evidence that any witness has willfully or knowingly testified falsely with respect to any material matter in the case, you are then at liberty to disregard the testimony of such witness with regard to other matters, excepting insofar as such witness is corroborated by other credible testimony. But you are the sole judges of the truthfulness of such a witness as well as any other, and you may believe or disbelieve his testimony with respect to other matters accordingly as you deem it worthy or unworthy of belief.
I was not keeping up, but follow
All right, we have any challenging words in this one? We had truthfulness.
Truthfulness.
Uncontradicted.
Oh, that one has a
Contradictions.
contra. Okay. contradicting. 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 Contrad
disbelieve. Believe or disbelieve.
My machine has decided to disconnect again. Yep, disconnected. To turn it off and on again. There, connected again. So annoying when that happens.
Worthy or unworthy. All right, back to some literary material. Court reporting is calling.
Okay, literary material.
Ready?
I am ready.
I loved working at the Capitol for 6 years in the House of Representatives, doing committee hearings and floor work, and then 5 years as a reporter of debates in the United States Senate, working with 7 other reporters, each day going to the Senate floor and having our work published in the Congressional Record. I would probably still be working there had my very dear friend Aunt Edna, as she was referred to by me, and so many who loved her, not gotten to the point where she needed constant care. Because of my years of government service, I was able to take early retirement, which I did. So we moved to Florida, where I became a full-time caregiver for almost 2 years. When Aunt Edna passed away, it was time to go back to work, and I thought about going to college and starting a new career, but court reporting kept calling me, and I went to work for Judy Conzer to begin a part-time freelance career. As only a court reporter would know, our job is pretty all-consuming, and though many are able to work and also find time to raise a family, I was incapable of doing both, and so I chose to be a career woman. I enjoyed other things in life, such as traveling, writing. I am now a published author, and volunteering. There was little time for socializing, but I found contentment in my work and helping others. If that meant foregoing marriage and children, so be it. Little did I know my life was about to change dramatically.
I did pretty good on that. I did miss a few sentences, but that's fine. Whatever. It's 120,
Right, back
so.
to some jury charge. The subject weighing evidence.
Please stop hitting the microphone.
Ready? You may take into consideration the interest of the witnesses in the result of the action, their appearance upon the witness stand, their demeanor in the courtroom, their relation to the parties, if any, and all the facts and circumstances in connection with the trial, and give to the testimony of each witness just such weight and credibility as you think it deserves. You are not to count the number of witnesses and render your verdict in accordance with the majority of them, but to weigh the testimony and render your verdict in accordance with the truth. It is the law that during the first 12 hours of your deliberations, you can only render a verdict by unanimously agreeing upon the verdict. However, if you fail to agree during the first 12 hours, the law permits you after that to render a verdict that has been agreed upon by 5/6 of your number. In case you render a unanimous verdict, it should be signed by your foreman as such, but if you render a 5/6 verdict, it should be signed only by those concurring in the verdict and not by your foreman, unless he be one concurring, in which case he will sign the same as the rest and not as foreman. You will select one of your number as foreman when you retire to the jury room, and when you have agreed upon the verdict, bring it into court if the courtroom is in session. If the court is not in session, seal up your verdict, give it to your foreman, and bring it in when court next convenes. If you agree upon a verdict when court is in session, you will not seal it up.
I'm doing pretty okay considering this is 120, but we'll see how I really do once I hit Q&A. That's always a humbling experience.
Okay, back to our literary material. Ready? Court reporting has brought many adventures to my life, but it never occurred to me it would one day bring a husband. In August 2013, I went to the Opryland Hotel in Nashville, Tennessee, to attend the NCRA Convention and Expo. I had a great time, and I ran into friends I hadn't seen in years. After the convention, I went to stay with a friend from Florida who had moved to Murfreesboro, just south of Nashville. She had been bugging me for quite some time to come and visit. The first night there, she invited someone from her church to join us for dinner. We met in August. He proposed in September, and we got married in November. My dad, who subsequently died in April 2014, was well enough to walk me down the aisle, which was an extra special blessing. So at the ripe old age of 57, I took my wedding vows for the first time and am now in the adventure of my life with the man of my dreams. it was a long time in coming, but well worth the wait. The only thing I don't like is I went from C, Colchio, to W, Robluski in the alphabet, and I don't like being at the end of the line. I now have 2 children and 3 grandchildren, and love them as much as if they were my own. My favorite scripture is found in Jeremiah 29:11. I know the plans I have for you, says the Lord. I am so thankful those plans included a career in court reporting.
I had trouble with that. I could not take down the names. I could not decipher them. The first last name that she said, I have no clue what it was. I had to just skip it deliberately because I didn't even know phonetically how to write it.
Get back to a little more jury charge practice, and this jury charge, the subject is assault and battery.
Assault and battery, okay.
Ready? Where an unlawful trespass is being committed upon the property of another, the owner may lawfully use the amount of force which is necessary under the circumstances for the protection of his property, either real or personal. However, he will be guilty of assault if he uses excessive force or any force after the necessity therefore is past. To justify a resort to force in defense of property, the danger should be such as to induce one exercising reasonable and proper judgment to interfere to prevent the consummation of the injury. Throwing a stone which is capable of inflicting grievous bodily harm at a person, even though such person is a trespasser, constitutes an assault if the purpose was to commit grievous bodily harm. Ordinarily, one who is in possession of premises lawfully and who has requested or ordered another to leave, whom he has a right to so request, may lawfully use as much force as is necessary to move such other, after allowing him a reasonable time to depart, and the trespasser may not resist if only reasonable force and agencies are used or employed in making such ejection.
There, ejection. It was ejection.
Excuse me. All right, let's get started with this literary. And the title is Practice. It's a necessity, not an option.
Necessity. I don't know how to write that. Necessity.
Ready?
Ready.
Practice is a necessity, not an option. It is clear that most program influencers understand this, as demonstrated by their top findings noted in survey outcomes. The National Court Reporters Association Instructional Best Practices Survey Executive Summary, published on March 20, 2015, stresses that practice and speed building
let me go to the beginning.
By their top practice is a necessity, not an option. It is clear that most program influencers understand this, as demonstrated by their top findings. Practice is a necessity, not an option. It is clear that most program influencers understand this, as demonstrated by their top findings noted in survey outcomes. The National Court Reporters Association Instructional Best Practices Survey Executive Summary, published on March 20, 2015, stresses that practice and speed building are essential components of a court reporting education and have a strong bearing on graduation rates. A state speed champion, national speed medalist, and past president of NCRA, Melanie Humphrey Sontag, RDR, CRR, CRC, suggests that a maximum of 4 hours of practice time a day should prove beneficial for students. She advises students to be consistent and dedicated, stating that the more you practice to cement your theory principles and muscle memory, the quicker you'll progress and the more accurate a professional you'll be. On top of this, NCRA suggests that in order to see positive student outcomes, program instructors need to ensure that students have access to continuous support for speed building and actively intervene if they suspect outside practice hours are not being observed. I suspect that program educators' deeper concern is getting faculty to rethink the entirety of curriculum development and teaching in the midst of the long-standing debate about the length and frequency of practice. If you've participated in recent discussions about court reporting curriculum development, inevitably you have witnessed the deliberations. Many seasoned court reporters argue that it's essential for students to practice, and practice some more. On the contrary, recent reporters share Brianna Ullman's sentiment in stating, it's not necessarily the amount of practice time that makes a difference, but the quality of your practice time that counts.
Once again, an article that doesn't really say much, even though...
All right, and that will conclude our literary and jury charge practice.
Did I like the last video? Leave a like? No, I did. I did leave a like. Okay, let me go to Q&A then. Q&A is gonna kick my ass.
Welcome to Q&A practice. Let's get started with the plaintiff.
Plaintiff, okay. Please don't
Ready?
be colloquy.
You wanted...
This is not a game. I'm practicing stenography for the next... Not really. It's gonna be in the next 15 minutes. Let me fix that. There, 15 minutes. Welcome back to the stream, though. I'm just practicing live. It keeps me practicing. I sometimes just end up not practicing the rest of the week and just do it on Thursdays, though, which is what I did now. I need to practice more and more and more.
All the stock.
Okay, that's too loud for me and my ears. Too loud. Put it at -5.
We formed the corporation.
Okay, yes. That's good.
The plaintiff.
Q&A.
Ready? You wanted all the stock. We formed the corporation and we discussed it. The stock was supposed to be issued when the corporation was set up. If I were called to testify, besides objecting on the basis of attorney-client privilege, and to that extent I am not waiving that right, the intention with regard to the children in trust was formed. At the same time, the intention to set up the corporation was formed. There wasn't any latter decision. Let me ask you, Elliot, why was the stock conveyed into the trust? Can you give me an idea for the purpose of establishing the trust? The trust was, as I said it already, you wanted the children to have the stock. The value of the corporation when I set up the two corporations was nil. There was no value. When I discussed it with my attorney, I said, if this is ever worth anything, I want it to belong to my children. If something should happen to me, then it would be conveyed to them. Did I answer the question? You wanted your children to have it, I assume, is the answer. Off the record. Paragraph 1 of the Declaration of the Trust. Do you have a copy of it? I should have copies of everything I provided you. I will read the pertinent part. Roman numeral 1 indicates that the beneficiaries are Jonathan Samuel James and Eric Randall James, that all of the net income will be applied to the trust estate prior to the termination of the trust. It is to be paid in monthly or other convenient installments to the beneficiaries. Have any monies been paid to the beneficiaries? No. Have the corporations had any net income? No. Who would make the resolution as to whether money or other convenient installments would be made? I think the document speaks for itself.
I didn't do very good on that. I did manage to write pertinent. So that's good, but not beneficiary. Beneficiary or heir.
All right, that was a nice little warm-up, and now we'll get to our transcript.
Okay, transcript.
Our other transcript.
Okay, I'm ready.
And we will start with the defense. Ready? And in what way was her language slurred, or did it just not make sense, or what was it that led you to that conclusion that she was confused when you were trying to determine her level of consciousness? She was unable to answer basic questions. Was there anything inconsistent with that state based on your experiences when with a pedestrian being struck at approximately 40 miles per hour? Objection, vague and ambiguous. I can rephrase it. Do you understand the question? I don't really know. Did you have an understanding when you first approached Ms. Waters that she had just been the victim of an accident at about 40 miles per hour with an oncoming vehicle? I wasn't told the speed. All I know that the call is an auto versus pedestrian, so I don't know the speed of impact. I didn't know how far the patient was thrown and what actually had occurred. All I knew was auto versus pedestrian. So it was fair to say when you approached her, you at least knew she was struck by a vehicle, correct? Possibly. And when you initially tried to assess the level of consciousness, determined she was confused, was there anything inconsistent in your mind based on your years of experience in this field with somebody being in a confused state after being struck by a vehicle? I'll object. It's an incomplete hypothetical, vague and ambiguous. It was not normal to me. What was it that was abnormal about that she could not respond to me, and that there was a strong odor of alcohol on her? So is it fair to say, in your experience treating approximately 10 of these patients per year, approximately, that are involved in pedestrian versus motor vehicle accidents, that you've never experienced a patient that was confused or unable to answer questions because of the mechanism of injury of being struck by a vehicle? I haven't experienced patients that have been in the same state because of being struck by a motor vehicle, meaning a confused state. Yes. Okay, once you went through that series of questions with her, determined that she was unable to answer those basic questions and she was confused, what was the next thing that you recall doing as part of the treatment and care you administered to Ms. Waters? We would have protected the C-spine and got her on a backboard. Did she appear to be in quite a bit of pain and distress at that point when you were doing that? Objection, vague and ambiguous. I don't recall. I don't know. And is it fair to say that the purpose to get her onto a backboard or into a C-spine is to protect in case of spinal cord damage, such as paraplegia, quadriplegia, things of that nature? Yes. And was that a concern that you had as a treating paramedic at the scene, that could be the case based on the mechanism of injury and what you were observing? Yes. And who was it that assisted you in that particular task, if you recall? It would have been myself and the 3 people on the engine company. And while she was being placed on this backboard, is that when you administered these tests and went through a number of the things that are identified here on this pre-hospital care report? I can't tell you exactly when all of them were done. It was either on scene or en route. This type of situation is a load and go type situation. It's a neurotrauma, and it's important to get them off scene as quickly as possible. So we do what's necessary on scene and what we have time for, and once the ambulance gets there, we load them in and continue all the treatment en route to the hospital. so I'm not sure what was done actually on scene unless it was documented with time. And were you one of the treating paramedics at the scene that made the independent decision that this was going to be treated as a head trauma case? Objection misstates his testimony. Do you understand? It's not an independent decision, but yes, I did make the decision. Collectively with the other treating paramedics? Yes.
I didn't do very well on that. I'm having such trouble keeping up.
That will conclude our...
It's so difficult. I can't even put it into words. Sometimes my brain just stops. That's not good. I need my brain to keep working when I'm doing this.
This is a 120 Q&A practice test.
I'm not gonna do good on this test. No.
Plaintiff attorney, Mr. Andrews, capital ANDREWS. Defense attorney, Ms. MS period Scott, capital SCOTT. We'll start with the defense.
Defense, okay.
Ready? She's thinking. Oh, she's thinking. I'm sorry. Don't let me rush you. I'm sorry. You're talking a long time. You're doing good. Can I ask a question? Sure, ask your attorney. Let's take a break. Take a break. Yeah, that's fine. Back on the record. Now, applicant had an off-the-record discussion with her attorney, and I noticed on the application, let me get the different. Here it is. You alleged, along with orthopedic, sleep impairment, anxiety, depression, stress, headaches, weight loss, and upset stomach. Did you want to dismiss any of those at this time? Yes. And which ones? Or all of them except for your orthopedic complaints? Or the orthopedic complaints she did not read onto the record. The complaints she read into the record are those that allege psychiatric component to your claim. Do you want to maintain any one of those, or go over each one individually and dismiss each individually, or keep each individually? How do you want to do it? If I dismiss it, does that say that it didn't happen, that I wasn't experiencing that at all? It means you cannot pursue your claim. I want to dismiss it. Okay, all of it. The only thing we're keeping is neck, shoulders, back, hips.
You know what? Let me restart this because I think I'm getting the speaker tags wrong.
Andrews, capital A-N.
Okay, restarting.
We'll start with the defense. Ready? She's thinking. Oh, she's thinking. I'm sorry. Don't let me rush you. I'm sorry. You're talking a long time. You're doing good. Can I ask? She's thinking. Oh, she's thinking. I'm sorry. Don't let me rush you. I'm sorry. You're talking a long time. You're doing good. Can I ask a question? Sure, ask your attorney. Let's take a break. Take a break. Yeah, that's fine. Back on the record. Now, applicant had an off-the-record discussion with her attorney, and I noticed on the application, let me get the different. Here it is. You alleged, along with orthopedic, sleep impairment, anxiety, depression, stress, headaches, weight loss, and upset stomach. Did you want to dismiss any of those at this time? Yes. And which ones? Or all of them?
I don't know who's the questioning attorney here. Okay.
Except for your orthopedic complaints, or the orthopedic complaints she did not read onto the record. The complaints she read into the record are those that allege psychiatric component to your claim. Do you want to maintain
psychiatric? Grit.
Psychiatric component to your claim? Do you want to maintain any one of those, or go over each one individually and dismiss each individually, or keep each individually? How do you want to do it? If I dismiss it, does that say that it didn't happen, that I wasn't experiencing that at all? It means you cannot pursue your claim. I want to dismiss it. Okay, all of it. The only thing we're keeping is neck, shoulders, back, hips, arms, and legs. Correct. Okay, and the other, some of them, I guess you almost call them internal sleep impairment, dismissing that. Upset stomach. Upset stomach, definitely that might be drug related, medication related. That's a separate compensable consequence. Don't worry about it. All right, dismissing all psychiatric related. Yes, we maintain our right if she does develop internal problems related to medication prescribed by the orthopedist. We may allege that as compensable consequence. You know, at a later date, if that happens, we can always, if we need to, we could do a depot at that time on that if necessary. Yes. Okay, great. All right.
I don't know who the questioning attorney is here. So I don't know which one is the Q and which one is in a colloquy.
We just finished up all the employment and all your work comp injuries and civil injuries. Oh, and okay, so we're not going to go over that. Okay, all right. Now let's go over your injuries you've had at, let's go over the injuries you've had at the school. Okay. Do you remember the first time you had an injury there? The first time that I noticed that I was having problems with my upper back was in May 2014. 2014, okay. And hold on 1 second. Okay, go ahead. And what happened at that particular time? Yes. It was at the end of the week. I just noticed that my muscles and my upper back and my neck and shoulders were just pretty tight. So that Friday evening, I just took a bath and hot bath and felt better the next day. Now, and okay, but that continued. But there's no question pending. Okay, I know we discussed the 85 injury to the upper back. Was this in the same area or a different area or of your upper back? I don't remember. You don't remember. Okay. And at that time in May of 2011, did you go to the doctor for my back? No. And you described it. You said it was like a tightness. Yes. Can you describe it for me any more, or just tightness? That's the best I can explain it. Okay, all right. Was it in both of your shoulders or more on one side than the other? I believe both. Okay. And what did you do next for it?
Okay. The end of that. I guess I can restart it though. I'll restart it again.
Capital SCOTT.
Okay, I think the defense attorney is the one questioning. You hear there's a pineapple hidden somewhere in your attic? Cool.
We'll start with the defense. Ready? She's thinking. Oh, she's thinking. I'm sorry. Don't let me rush you. I'm sorry. You're talking a long time. You're doing good.
Oh my god. It goes so fast.
She's thinking. Oh, she's thinking. I'm sorry. Don't let me rush you. I'm sorry. You're talking a long time. You're doing good. Can I ask a question? Sure, ask your attorney. Let's take a break. Take a break. Yeah, that's fine. Back on the record. Now, applicant had an off-the-record discussion with her attorney, and I noticed on the application, let me get the different. Here it is. You alleged, along with orthopedic, sleep impairment, anxiety, depression, stress, headaches, weight loss, and upset stomach. Did you want to dismiss any of those at this time? Yes. And which ones? Or all of them except for your orthopedic complaints or the orthopedic complaints she did not read onto the record. The complaints she read into the record are those that allege psychiatric component to your claim. Do you want to maintain any one of those or go over each one individually and dismiss each individually or keep each individually? How do you want to do it? If I dismiss it, does that say that it didn't happen, that I wasn't experiencing that at all? It means you cannot pursue your claim. I want to dismiss it. Okay, all of it. The only thing we're keeping is neck, shoulders, back, hips, arms, and legs. Correct. Okay, and the other, some of them, I guess you almost call them internal sleep impairment, dismissing that. Upset stomach. Upset stomach, definitely that might be drug related, medication related. That's a separate compensable consequence. Don't worry about it. All right, dismissing all psychiatric related. Yes, we maintain our right if she does develop internal problems related to medication prescribed by the orthopedist. We may allege that as compensable consequence. You know, at a later date, if that happens, we can always, if we need to, we could do a depot at that time on that if necessary. Yes. Okay, great. All right. I think we just finished up all the employment and all your work comp injuries and civil injuries. Oh, and okay. So we're not going to go over that. Okay, all right. Now let's go over your injuries you've had at, let's go over the injuries you've had at the school. Okay. Do you remember the first time you had an injury there? The first time that I noticed that I was having problems with my upper back was in May 2014. 2014, okay. And hold on 1 second. Okay, go ahead. And what happened at that particular time? Yes, it was at the end of the week. I just noticed that my muscles and my upper back and my neck and shoulders were just pretty tight. So that Friday evening, I just took a hot bath and felt better the next day. Now, and okay, but that continued. But there's no question pending. Okay, I know we discussed the 85 injury to the upper back. Was this in the same area or a different area or of your upper back? I don't remember. You don't remember. Okay. And at that time, in May of 2011, did you go to the doctor for my back? No. And you described it. You said it was like a tightness? Yes. Can you describe it for me any more, or just tightness? That's the best I can explain it. Okay, all right. Was it in both of your shoulders or more on one side than the other? I believe both. Okay. And what did you do next for it?
Okay, I tried that 3 times. The third time, I think I was even worse. But at least I finally understand which person was the questioner and which one was in colloquy. That's the most I can do. Okay, let me... Okay, the browser is no longer showing. Good. Okay. Let's see, I'll rate the Space Jays. They're currently playing The Legend of Kimori again. I'll be back tomorrow for the 100 line. Happy to be playing that game again. It's gonna be awesome. Goodbye.